Good afternoon and welcome back. My name is Azim. I teach at the National University of Singapore. We've had two excellent sessions in the morning where we discussed broad themes in legal reform and then we discussed issues in the criminal justice system. Our third session today features four panelists, two of whom will be joining us through Skype and through other forms of technology that I'm not fully aware of. The broad topic is civil justice reform. If you see the program, the organizers of the conference have basically kept up the focus on the Indian legal system. As the theme note for the panel sort of informs us, it's been a decade since we've had substantial legal reform in India. And the theme note talks about the Code of Civil Procedure Amendment Act of 2002, which was the last major reform of the civil justice system. Right? As the note indicates, the attempts were made to set time limits on submission of claims and written statements. There were also attempts to control the way adjournments happen. And as we know, there is a lot of opposition to it by the organized legal profession. Pratap Mehta has actually written about that process. And we know that a lot of those reforms didn't actually take hold. Some of the papers today are going to talk about why that has happened. And people are also going to present empirical data on aspects of the legal system that perhaps contribute to the failure of those reforms. Right? We're a little short of time. I've asked that we have four speakers, each of whom is going to try and aim to complete in about 20 minutes, which will hopefully leave us enough time for discussion at the end of it. I won't, all of you should have the bios of the speakers. I won't go into a very detailed explanation of their bios. Very briefly, Osama Siddique is our first presenter. Osama is now an associate professor of law and policy at LUMS, the Lahore University of Management Sciences. He will speak first, and unfortunately we won't have a question-answer session. Osama was supposed to be with us, but visa difficulties sort of prevented him from being with us physically. We will try and collect questions and comments and send him by email, and hopefully that exchange can happen later as well. I understand Osama is going to tell us a little about his recent research in Pakistan, and that will probably throw a comparative dimension on issues that we talked about. This will be followed by Nandakishore's presentation. Nandakishore is an advocate on record in the Supreme Court, has taught earlier at the National Law School. His paper, which was circulated, I think, to the presenters, is a very interesting take which draws from his experiences of being a practicing lawyer, dealing with the CPC in a very sort of real way, and also as having taught CPC, his experiences as someone who's been an academic in the area, and he makes a call for what legal scholarship should be doing. Sheetal Kalantri is our third speaker. She's an associate clinical professor at Cornell Law School, and I think that paper was also circulated earlier on litigation rates in India, assuming she's going to draw from some of that work. Our final speaker is Vikas Kumar, who's an assistant professor at the Azim Premji University. I think Sudhir mentioned in the morning that there will be people from the project presenting work done, and I think that work is an empirical study of tendency and other issues in the Indian context. So I'll hand off the floor to Osama, and we'll hear from him for the next 20 minutes or so. Yeah, thank you.
The thing is also a bit truncated, which is fine as long as you can hear me.
Yes, Osama, I think you're quite clear for us.
Okay, if I'm audible, then I'll just go ahead because sometimes I can't hear clearly. Thank you very much for the introduction. I wanted to thank Dr. Sudhir Krishnaswamy and the Azim, Premji University for extending an invitation to me. I dearly wanted to be there, but unfortunately the visa did not arrive in time. But I'm very, very happy to be there virtually. There are many friends there in the audience as well whom I can't clearly see, and there were new ones I was hoping to make. But hopefully next time. Now, looking at the context of this particular panel, I thought that I would perhaps share some brief background of how we have approached justice sector reform in Pakistan, and I think there are some interesting differences. There may be various areas of commonalities when it comes to the actual problems. One of the things which I want to highlight is the necessity of empirical work to try and sort of approach reform in a more meaningful fashion. The working paper, which I believe may have been circulated amongst you, is a report of a survey which was conducted by myself and my students last year. And it's quite remarkable to me still that despite the fact that what we were asking is fairly commonsensical, straightforward, intuitive, there's hardly any such empirical data currently sort of available generally in South Asia. The context of reform in Pakistan, and perhaps one dimension which makes it different from India, is that in the short years onward, we've actually had a lot of international financial institutional funding for justice sector reform. To date, the world's largest soft loan, the US $350 million loan for justice sector reform, was extended to Pakistan under the Asian Development Program. I've actually been associated with that program in an advisory capacity, and then subsequently I have done a lot of research in trying to understand what exactly were the design and implementation issues of that particular program. Now, one very sort of interesting dimension of that particular program is that it was very much focused at one level on core efficiency enhancement, which of course has a linkage to the entire international law and development debate about rule of law reforms and how efficiency can come with a typical package. But quite apart from that, it's quite interesting, the more I look at it now, how this entire efficiency tweaking reform agenda proceeded forward without any real empirical basis. One of the main issues which I have noticed as I started empirical research on the Pakistani court system is the sheer paucity of data which is officially generated. And I'm quite surprised that despite the millions of dollars which are actually spent on this reform program, there was no real attempt to sort of develop baselines or inculcate cultures of constant data collection. I mean, the situation is better than before. The high courts produce annual reports. But the problem is that there are lots of sort of inconsistencies between various courts. The other problem is the data is at a very sort of aggregated level. So you cannot really get disaggregated information if you really want to make policy interventions about which are the areas where most of the litigation is taking place. I mean, we intuitively know that it's land and property, but to pin it down even further, which are the areas which are creating extra litigation because of a flaw in the law, a procedural problem, any other issue. The other dimension of this entire justice sector reform, and this goes directly to the heart of ordinary citizens' interaction with the criminal and civil justice system, is that to what extent does the court system still continues to aid rather than empower and create as much of a level playing field. Now there's, of course, rich historical literature in the Indian context by Mark Galanter and various other people who have not only sort of looked at the Lok Adalat and the Naya Panchayat experience, but one story which seems to emerge is that the inherited colonial system in many ways has been indigenized, accepted. It is problematic, but there is no other alternative. And I was very curious to see in the Pakistani context as to what sense, in what way, alternative dispute resolution mechanisms or mechanisms outside the formal court system still exist. And therefore, we designed this particular survey because, frankly, from a lot of the earlier policy reports, things were not really explored at that level. Now, the survey report, which you probably have, and I'll share it if people don't have it and if there is interest, is essentially a fairly extensive politico-economic kind of survey followed by interviews. We basically finalized 440 interviews in about 10 days. I worked with about 23 or 24 of my students in the Lahore Zilla Kacheri of the district courts. Lahore is the most socio-economically developed tehsil and district in Punjab. And the questionnaire actually tried to get public perception of their current experience with the formal legal system. Am I with you so far? Can you hear me?
Yeah.
Okay, thanks. So broadly it was divided into 10 sections. The first section looked at personal and household information of the respondents. And the second looked at the location, nature and background of the disputes, because hardly any justice sector reform work, at least in Pakistan, has actually looked at the nature of the dispute and the kind of complex socio-political dimensions to the dispute in order to understand why does it translate into so much litigation. The third looked at the nature and duration of the legal proceedings, the third section of the questionnaire. The fourth looked at whether the dispute had actually translated into a viable legal remedy. The fifth looked at litigants' perceptions about the resourcefulness and leverage of their opponents. Just to get an idea of where people perceive themselves to stand in a court of law. It's obviously not a level playing field, but what exactly is their perception? The sixth looked at people's experience and perception of non-court dispute resolution mechanisms. And we looked at both endeavors by people to negotiate a dispute face-to-face, as much as using Biradari, which is clan, panchayat, khandan, other mechanisms, former, state or non-state mechanisms. The seventh module in the questionnaire actually looked at various other variables, which obviously have an influence on how well do you do in a court, such as knowledge of the English language, familiarity with procedure, past litigation experience, familiarity with the court processes, and perceptions about we also asked questions about the perception about the neutrality of law and the fact whether law actually captured ground realities and people's actual problems. The eighth section then asked specific questions about the court experience. So you will notice that the first 7 sections actually looked at various issues before coming to court, and then we moved to the court. Perceptions about judges, neutrality, integrity, efficiency, court staff. Section 9 looked at lawyers, and then section 10 asked them about future preferences in terms of forum. Would they like to come back to the formal court system again? And let me share with you what I thought was a fairly stark finding, which is really the conclusion in some ways from module 10, because this question was about 112 questions. Now, the interesting thing is that when asked whether they would come back to the formal court system, the civil court system, with a similar dispute in future, 42% of the people said no. 10% said that they were unsure, and the remaining 48% said that they would bring the case back to the civil court system. So 42% are saying we would not like to be caught up in the civil court system again. But we further probed those 48% who said that they would come back to the court, and we asked them what would be the reason why would they come to court. Are they satisfied with the court? Is there no other alternative? Why would they come back to court? Is there a positive reason, or is it lack of choices? And when they were put this question, it turned out that from amongst those 48%, only 16% said that they would like to come back to court because they were satisfied with the court's performance. 1% said that they would opt in the court for the future because it's a cheaper dispute resolution mechanism. 77% people said if there was another alternative, an informal dispute resolution alternative, they would rather do that. So if you combine this particular segment along with those who had categorically said no earlier, it turns out that 81.5% or much over 3/4 of the litigants are saying that they don't want to come back to court. Now, mind you, as I already said, that this is the Lahore is the most advanced district in the Punjab socio-economically, according to the various indicators and government surveys. So one can imagine whether people have something even more adverse to say as you get away from the centers of power. Because the Lahore district courts are a couple of kilometers away from the Lahore High Court, and that's where the bulk of the reform action, the funding, the scrutiny has been. I can't go into all the data about alternative dispute resolution mechanisms, but I'm quite sure that the answers would vary a lot from district to district. But in a nutshell, a lot of people are saying that they'd rather resolve issues out of court, but they don't do that because either these non-court dispute resolution systems are dysfunctional, or they do not have an implementation mechanism, or even if they try and implement their judgment, the opponent would flout it because it's so easy to come to court. The barriers to entry are so low. The other question about, which is also in this survey report which may have been circulated, was about the nature of the disputes. And once again, there's a very interesting sort of staggering of the various kinds of disputes. As many as 15% of the cases stuck up in the civil court system are rent cases, which is quite remarkable because considering that mostly these cases don't have either a public policy imperative or a fundamental right at issue, the question can emerge as to why those take up so much time in the court system and why those can't be taken out. But the larger argument I'm trying to make is that there's huge dissatisfaction with the civil court system. There is almost a nostalgia about for not creating this sort of apartheid of forums. But the picture here is clear. I mean, if you keep out special territories in Pakistan like FATA and FATA, if you talk about mainstream Pakistan, if you talk about the mainstream inherited colonial legal system, which is more or less identical to yours, there's a huge amount of disillusionment. The other dimension which gets neglected is how disadvantaged different litigants can be when they come to the civil court. I mean, you assume that the court is the great equalizer. But I was actually quite shocked to see that even in the socio-economically developed district of Lahore, in terms of personal and household indicators, 63% of the litigants whom we interviewed said that they had a household income equal or less to rupees 20,000. 83% fell in income less than 50,000. And within this, the subcategory of those whose household income was below 10,000 were 38.5% of the respondents. Now, if you have a monthly household income of of less than 10,000, and you are stuck in a court, you must be really desperate because surely you would much rather resolve that dispute out of court. If you actually ask them about the average financial outlay on litigation, 38% are saying that it's as much as rupees 50,000. 50% are saying it's greater than 50,000. 38.5% are saying that they've spent up to rupees 200,000 or that they have lost count because they've been spending money on litigation for such a long time. So the gap between the cost of litigation and the actual financial viability of the litigants comes through. The other really important dimension, and I don't know what the experience in India is, language. We have translated certain laws into Urdu and other local languages, but by and large, court proceedings in the appellate courts are still in English, and in the district and the lower courts, you use a mix of various languages. But it's interesting considering such a large chunk of the population which was litigating was uneducated or had education less than primary school. I'll give you the number. 26% of the 440 litigants were either illiterate or they had education less than primary school. So obviously when you ask them questions about familiarity with the English language, the numbers are very low. And even those who say that they are somewhat familiar with the English language, when you actually ask them the question that you said you were familiar with the English language, how familiar are you with court documents, the court proceedings, the court procedure in English language, the number drops much further. So, it's almost like a pantomime is taking place still in the 21st century in front of a lot of muted people who simply cannot comprehend as to, the pantomime which is sort of being unable. They can't hear it, they can't understand it. 59% of the overall respondents said they either did not understand English or only somewhat understood it, right? And when we focus on the almost 60% of the respondents who said that they did indeed understand English or they somewhat comprehended it, so 50% because we included the chunk of those who said they had somewhat of comprehension, it emerged that 56% of these people did not comprehend laws in English or legal proceedings in English. So the number really, really goes up. Like India, the main complaint is about delay. But delay is not the only thing being reported. I mean, it was difficult for the respondents to answer direct questions about judges, because obviously they were reluctant. It was also difficult for them to answer questions about lawyers directly. Lawyers were more milling around when we were doing the interview. But when we asked a whole host of indirect questions about their experience, lawyers, judges, delay, all these things, obviously get reported. 81% of them said that there was a lot of delay. 13% said there was a fair bit of delay. Almost 90% of the people are complaining of delays. Other than delay, cost of litigation, attitude of the lawyers, complexity of the legal system, financial corruption, judicial attitude, distance of court from home. These are in a descending order of responses, but there are a whole host of issues. But I think it is also very important to look at the fact that we asked them the question, a generic question, whether they thought that the Pakistani laws were outdated. They did not have a connection with the current sense of reality or the actual on-the-ground issues which people face on the ground. And 56% of the people agreed with that. Importantly, another 54% fully or partially agreed with the assertion that they thought that the laws were not really promoting a notion of equity, that they were biased in their particular case. Now, this can be a very partisan view, and obviously we're talking about perception. But the first response is very interesting, where almost 60% of the people are saying that they think that the laws are outdated. Now, of course, when I ask why do they think it's outdated, some of them, a very small percentage, by the way, of the people said that they would like an Islamic system of law. Most of the response was, look, the system is outdated. These laws were made so many hundreds of years ago. There hasn't been adequate legislation. And considering the education levels and everything of most people, they were remarkably candid, remarkably detailed in terms of their lived experience with the legal system. My point in sort of sharing this particular survey is that it can, of course, maybe be much more sophisticated. They can be a very, very different approach. We can actually take cases from the roster of a particular court and follow them to the source. This was a different methodology. Here we randomly met people turning up in the Lahore district court, where there are about 70 to 80 different kinds of civil courts, trying to cover every floor, trying to cover every particular court. I had students covering all of them, and trying to ensure that whoever is willing to speak to us, we speak to them. Now, there can be a sample bias here, simply because those who are more affluent or have more leverage may not feel it necessary to actually turn up at the district court. Their lawyer can do their job. And we were only talking to the litigants. So I concede that there may be a bias in the sample towards the less privileged people because of that reason, but surely there can be various other ways of augmenting this data. But I think more to the point, it is still important that if these were the people who are the least advantaged in the court system, at least we got a good cross-section of them over 10 days to find out what they feel. And yet it's interesting, because when you go to reform discourses with judges and a lot of people, it's amazing the power of data, because once you put data on the table, the dialogue of course changes, because otherwise if you say the very same things based on literature and all that, the back response is, sir, that is your perception, my perception is different. Or you may be saying that a lot of people are suffering. My experience as a judge for 25 years is that 95% of the litigation is frivolous. Now, there may be some truth to that experience, but I really feel that if we are to move to a more nuanced, segmented analysis of justice sector reform, we'll have to collect very, very sophisticated data. And this is work which will have to be done in a much more interdisciplinary fashion. Because frankly, a lot of the issues which these people are facing are not just legal issues, they're sociological issues, issues of political economy. Legal empowerment in many ways is the flip side of economic disempowerment. Interestingly, in the Lahore District Court's survey, caste, clan, and ethnicity, and sect did not turn out to be statistically important variables at all. I mean, gender was somewhat important, it had some interesting results. Economic status was important, education was important. But I think that the aforementioned four parameters could become very important depending on which parts of Pakistan you're in. So I think if law reform has to both focus on particular laws and particular procedural reforms, and if it also has to come up with some empowering steps in those areas which are facing particular issues, there'll have to be much more disaggregated data collection. There'll have to be much more focused region and area-wise analysis of people's actual experience with the law. One thing which became very clear is, from a previous survey which I conducted, is that when it comes to the prevalence of dispute resolution mechanisms and people's faith in that, there are of course problems with that as well. There's a huge amount of variation even within Punjab, and I'm sure that's the same in India. So surely, if some homegrown solutions are going to be very carefully used to take some of the load away from the court system and to provide some fairly ready and intelligible and cheap justice to people for issues which do not, and I qualify that, involve any important fundamental rights, then you'll have to have a very region and area-wise focus as well. Currently, we don't have that. I mean, the data is so aggregated that you essentially get data at the level of provinces or at the level of the high courts. And that, frankly, can only give you some idea of what's happening. The larger picture you get, for example, from the 10-year data for the 4 high courts is that while case disposal has gone up, judges are disposing more cases, case initiation on new cases have gone up by a larger factor. So the gap between case disposal and case pendency is constantly growing. If that is the case, then the question which really emerges is why so much more litigation? Is it just population? Is it that there are new kinds of disputes in society emerging because of urbanization, access to land? Does the law really need to respond to that, or should it be regulation? Frankly, that dimension or those multiple dimensions of the analysis are largely lacking, both because of how the research questions are structured and also because a lot of this is actually conjecture in the absence of data. I think I'll stop there. My time is more or less over. I'm not sure also whether you were able to hear me. In case there, somebody wants a clarification, there's still any time left, I'd rather respond to that.
Thank you, Osama. Can you hear me? Osama?
Yes, I can.
Yeah.
Did you hear me?
Yeah, we could hear you. I think it was much clearer at our end than it seems to be at your end.
Oh, great.
So thanks very much. What we'll do is we'll collate some comments and questions for you and maybe communicate them to you over email.
Sounds fantastic. I think I should go off now so that somebody else can come on your screen now. Sure. You could do with a good change.
Thank you, Osama. Take
care.
Okay.
Lovely talking to you. Thank you so much. Bye-bye.
Bye-bye. Okay. I skipped the commentary and we'll probably move to Nandakishore, who will take us from a survey approach to it to a more sort of personal reflection as a practitioner, as an academic, on the subject of civil procedure.
Sorry, I just tried not to use the podium. But you could, everybody, my topic is Indian civil procedure, scholarship urgently wanted. The law of civil procedure in India is the legacy of some of the finest English jurists of their time. The Indian Evidence Act 1872 was enacted in 1872 and was drafted by the distinguished Sir James Fitzjames Stephen. The CPC was enacted first in 1859 and revised again in 1877 and 1882, and finally revised again in 1908 when a select committee presided by Sir Earl Richards rearranged the provisions of the code into 2 parts, the body and the schedule. Now the English jurists had a very onerous task in front of them. The existing legal system was very chaotic. They had to create a coordinated system of courts. They had to create unified and well-defined systems of rules for the first time. And codification seemed the natural answer to the lack of certainty and uniformity. In Macaulay's words, I believe that no country ever stood so much in need of a code of law as India, and I believe also that there never was a country in which the want might be so easily supplied. Our principle is simply this: uniformity when you have it, when you can have it, diversity when you must have it, but in all cases, certainty. Now, most of us Indians, we have always been in awe of the Civil Procedure Code and the Indian Evidence Act. The Law Commission reports are full of praise for these enactments. Changes have been considered and reforms have been effected over the years, but they tend to be generally cosmetic, cautious and apologetic. The persistent opinion is that the Civil Procedure Code and the Indian Evidence Act and the system of procedural law that they create is fundamentally sound. The ship is, as one of the law commissions put it, the ship is well designed, fundamentally sound. We are forced to conclude that since the ship is fundamentally sound, the problem is not of procedure, but only of infrastructure. What I'd like to suggest to you today is that even though the ship is fundamentally sound, the ship might not have been run properly by us. The provisions of the code are inadequately theorized, and we are yet far away from arriving at the principles of Indian civil procedure, as opposed to a mass of rules and cases that are not adequately reconciled. This lack of clarity and theory adds to delays and also affects the quality of dispute resolution that the civil justice system delivers. I'd further like to suggest that in addition to this lack of micro-theorization, India also suffers from what I'd like to call a lack of macro-theorization about civil procedure. That is the consideration of the procedural system at a macro level, not just the individual rules and the theorization of the individual rules, but at a broader level in terms of tailoring the system so as to best meet the needs of the system. Now, this lack of scholarship at the macro level also affects the way in which we effect reforms. Now, the stimulus for this paper has come from three different ways in which I've been interacting with the civil justice system over the years. First, as a courtroom practitioner in India for more than 12 years at the trial, appellate and Supreme Court levels, I rely upon my personal experience of the way in which the civil procedural system operates. I hasten to clarify that this is documented and evidenced by my detailed notes of cases conducted over the years. Some 570 cases at trial and appellate level, and some 370 cases at Supreme Court level. I'm afraid I'm revealing the details of my practice also through this, which is not something a good lawyer should do. Because yes, either way you're in trouble. Because if you have too small a practice, that doesn't say very much about you. And if you have too big a one, then you have to account for it to the income tax department. Just kidding. Now, so these are the cases, and I would say that out of the 570 cases at the High Court and lower court level, at least about 100 of them deal with issues of civil procedure. And out of the some 370 cases at the Supreme Court level, about 80 of them deal with civil procedure. So I've used these notes as data for my conclusions. What I found is that that lawyers, judges and litigants are unsure and unfamiliar about the basic principles of civil procedure. Very often when questions of civil procedure arise in courts, these questions are relegated to the discretion of the judge. Interpretive issues that arise from the courts are not adequately dealt with. Usually a mass of case law is found under each section. There are conflicting High Court decisions. If you're lucky, you'll get a Supreme Court decision. But even if you get a Supreme Court decision, you'll find upon reading the decision that there isn't sufficient articulation of the rationale or the principle underlying the rule in question. So there'll be a decision, yes, there'll be a decision, but there won't be sufficient articulation of underlying principles and doctrines. The second area where I've got a stimulus is that is from my teaching stint at National Law School, where I taught civil procedure for one term. Most students find civil procedure incredibly technical, tedious and boring. There's a mass of rules and cases that have to be ingested. The object and purpose of the rules is not clear from a bare reading of the rules. Some of the rules seem counterintuitive. Comprehensive textbooks that explain in a clear and precise manner all the rules and cases that have been decided are not to be found. We still rely upon Sarkar's Code of Civil Procedure, which continues to be a standard work revised several times. There the civil procedure code is laid out, and all the decided cases that the author can lay his hands on have been reproduced under each section. High Court and Supreme Court decisions. No attempt is made at reconciling the cases with the section, nor at getting to the underlying principles. Before exams, students who haven't been paying attention in class would rush to get Mullah's Key to Indian Practice or Thakkar's Civil Procedure. Both are well written books, elegant, but too elegant. Not deep enough, and don't attempt a comprehensive answer to all the issues that arise in civil procedure. Like Gandhi once said, students might also say that civil procedure is beyond me. The third stimulus comes from the findings of my MPhil thesis at NLS, which was on inquisitorial techniques of fact-finding in Indian civil trials. It was primarily a doctrinal study, but there was a small empirical component. It was noticed that there are several provisions in the Indian Evidence Act and the CPC which empower the trial judge to take an active part in the search for truth. For example, section 165 says, of the Indian Evidence Act says, the trial judge may summon any document he wishes or ask any question he wishes of a witness. So the question was asked, the research question was asked, looking at these provisions, what is the true role of the trial judge in India in a civil case, especially in the fact-finding process? Can he interfere in the trial and get evidence suo motu and bring it on record? If he can, how far can he go? Can he take over the whole trial? The doctrinal study revealed that, first, the Supreme Court had indeed advocated a proactive role for the trial judge. He was not required to be a potted plant, as some people have pointed out. That's the phrase that some people use. Secondly, and crucially, the Supreme Court had not articulated clear guidelines as to the use of inquisitorial powers. There was no attempt at articulating a doctrinal and theoretical base on the basis of which a trial judge could confidently intervene. There was no theorization on it. I conducted an empirical study, a sample study, involving some 34 trial judges in Bangalore and small towns around Bangalore. And this empirical study revealed that most judges didn't know how to use the provisions properly. They had not understood the scope and ambit of the sections. Most of them had never used these powers because they were afraid that if they used it, they would be seen to be impartial. Partial. Now, section 165 of the Indian Evidence Act has been a part of the Evidence Act since inception. Even now, if Indian trial judges don't know how to use these sections, and there is no guidance from the Supreme Court, nor from any of the textbooks, what about the provisions in the other enactments? Now, we all know that rules are tricky creatures. When you look at them from afar, they are very neat and pretty. But when you want to actually apply them in concrete cases, they throw up interpretive issues. This is well researched by several scholars. Hart, for example, his famous no vehicles in the park. If there's a battery-operated wheelchair, will it be allowed into the park? Or if there's somebody in an ambulance, will he be allowed to go through the park? Interpretive issues inevitably arise with statutes. And interpretive issues are the price to be paid for codification. Now, in order to resolve interpretive issues, you need to get to the object of the rule, the purpose of the rule, and the rationale of the rule. With the common law principles, this is not very difficult usually, most of the time, because there's a detailed judgment which is given and which articulates the background rationale for the rule in question or for the principle in question. But with statutes, especially statutes like the CPC and the Indian Evidence Act, and the complexity of the code makes it so. Now, Ronald Dworkin, you all know, I'm sure you know his famous works, argues that in order to know your law, it's not enough to just know your cases and your rules. What you need to know is the body of principles or the theory that underlies these cases and rules and best justifies them. So if you accept this, then it's clear that from this perspective, we are yet far away from arriving at the principles of Indian civil procedure. All we have is a mass of cases and rules. Any textbook will show you this. And there are no attempts at reconciliation. Now, I've asked the question, why is civil procedure undernourished in India? And I've come up with a number of probable answers for that. The reasons could be the following. First, the Supreme Court, as seen in the interpretation of provisions relating to inquisitorial powers, has not developed sufficient jurisprudence on civil procedure. The banal examinations in order to become judges. But High Court judges and Supreme Court judges don't pass any such exams unless they've been elevated from the trial court level. And if they haven't practiced at the trial court level, then the knowledge of civil procedure will be even lower. Unlike in other areas, borrowing from Anglo-American scholarship has not been very easy. Scholarship on here I may be wrong. Scholarship on civil procedure appears to be a rather neglected area, even in the UK and the US, because I haven't found many departments in universities which devote themselves to the study of civil procedure, nor many people who call themselves experts on civil procedure. Now, what are the effects of this malnourishment in the jurisprudence of civil procedure? These could be, one, large portions of the procedural codes are not really understood by lawyers and judges and are consequently unused. This has been noted by the law commissions. For example, provisions relating to examination of parties by the court, discovery and inspection, admissions, striking out of pleadings, the detailed rules of pleadings, settlement of issues, costs, special case, restitution, etc. are either misused or not used sufficiently. The quality and, needless to say, the quality and productivity of the civil justice system suffers. The lack of clarity in civil procedure means that uncertainty abounds. In an uncertain system, the litigant is the most perplexed entity. His control over the dispute slips even further, kept in awe by the mysterious workings of the legal system which only his lawyer might understand. Access to justice is further weakened. In the face of procedural uncertainty, judges become more powerful. It's the rule of judges and not the rule of men. I mean, it's the rule of, it's not the rule of law. Disputes take longer than necessary to be resolved because on many procedural errors, remands are effected by the appellate courts. Fifth, radical reform of civil procedure will be difficult. Without the necessary scholarship to take on the codes, reformers will only suggest apologetic, cautious and cosmetic changes in the system. Take, for example, sections 6 to 16 of the Indian Evidence Act. Even the great James Fitzjames Stephen has come under attack for these provisions because he's reversed a principle of English law, which is that everything which is probative goes in unless it is excluded. But he sought to define relevancy and admissibility, and this has been severely criticized by scholars such as James Bradley Thayer. But we haven't had the courage to rework the Indian Evidence Act. All this is about micro-theorization. Okay. Now, talking a little bit about macro-theorization, contrasting macro-theorization with micro-theorization is about considering the civil procedural system in a broader manner, at a macro level. I could compare this to temple architecture. Okay, if you look at a South Indian temple, if you go close, you will see small statues and this and that, and you'll study the temple architecture in a miniature. That's the study of the rules of civil procedure. But if you stand back, suppose you stand 100 meters away from the temple and look at the structure as a whole, that's what macro level understanding of civil procedure is all about. So even here I find that there's very little scholarship in India. And I'd like to point out some 5 or 6 different areas where we would really benefit from getting into the discourse on procedural systems at a macro level. Now this is taking place in small pockets around the world by very interesting scholars on civil procedure. And we should definitely be a part of this discourse if we want to effect far-reaching and interesting changes to our legal system. First area is the goals and objectives of procedural system. What is the civil procedural system all about? Why do we have a civil procedural system? It's about resolving disputes, sure. But what does it mean to say that you resolve a dispute? Judges often say that it's just about getting to the truth of the matter. If you want to apply contract law, you first have to come to a finding that there was a contract. Only then you can enforce contract law. So it's just about accuracy in fact finding. But it's not as simple as that. Because if that were the case, you wouldn't have just 3 appeals, you would have 100 appeals. You wouldn't have concepts such as res judicata. You wouldn't have time limits for trials and for various stages of the trial, it's obvious that the search for truth is limited by very many constraints, such as time and costs. So these are other goals in the procedural system. So then the question arises, how much weight do you want to give to truth in your system? Now, unless you know what your system wants, or what you want from the system, you're not in a position to effect changes in the system. And how do you answer what your system wants? Is it a question of constitutional law? Is there a constitutional right to civil justice? Efficacious and speedy civil justice? These are very difficult issues on which we have no scholarship. Then I'll just quickly run through the other ones because I'm told that I'm running out of time. Historical and sociological factors that are responsible for the structure of procedural systems. Then the anthropology of procedure in India. If you look at the ordinary rural litigant stuck in the civil procedural system, you could easily write a book like Naipaul. You know, like Naipaul, like observe the skinny villager Ramana in dusty clothes, sitting on the benches of the lawyer's office for a simple partition suit. So you could easily write a story, heartbreaking story. Then empirical studies, but there's not much done, I think, on the anthropological side. Empirical studies and procedural reform, I don't have to say anything about that. Then legal law metrics. Now, the procedural system is like any other system. So it's got outputs, it's got inputs. So can you use tools which are similar to econometrics to maximize the output? Lots of scholars are doing interesting work on this. Then comparative procedural law. That's also another area which would be very fruitful for study. So I'd like to conclude by saying that as Indians become more and more urbanized, more and more literate and aware, and begin to demand better governance in all areas, we will surely begin to intensify our agitation for better civil justice. And we will not be able to effect the reforms we need unless we arm ourselves with the necessary scholarship, both at micro and macro levels. Until that happens, we will continue to treat our codes the way in which we treat our great iconic leaders like Gandhi and Nehru and Ambedkar. Considered great from afar, but never studied too closely, lest we be required to imbibe any of their qualities. I may be forgiven for ending with a poem I was driven with despair to write in a CPC class. Ode to the Code. O seamless web of myriad intricacies, a constant reminder of colonial fantasies. As tiny little rules at each stage we ungarble, thy lovely form is more and more revealed, a marvel. Purpose, rationale, concept and meaning, yet grapple with black-lettered legal reasoning. How we would love to know every inch of you, move effortlessly from section 11 to order 2. But many secrets you still hide from us, to taunt us, tease us and then delight us. You have a darker side we do see, entangling poor litigants in rule complexity. Landlords and tenants, husbands and wives. Merchants and farmers, people with lives. You are the lawyer's burden, the student's despair. And many say you simply pretend to be fair. Can anybody ever fall in love with you? Read all your sections and then say I do? People wonder, stop and stare, see me with you almost everywhere. They don't know the times we've had together. Cozy library spots knowing each other. The pain and suffering and joy we've been through, reading each other anew. So I don't much care for the laughing hordes, for you are my princess, sweet princess of codes.
Thank you. Osama talked to us about the despair of 440 people in Lahore. Nankush shares a different kind of despair about the civil procedure code. I think we're waiting to hook up with our next presenter, who's also going to present, I think, as we said, we probably circulate some of the papers which some of us had access to earlier. And this paper is also a large study of litigation rates in India. I think Nick Robinson is also one of the authors in the study. So she can present that. Just so that we know, there's a slight concern about time, that we have to leave the hall at 4:30. So she tells once we connect, we'll hopefully go on time, which will probably leave only about 10 minutes at the end for discussion. Hopefully we can stick to that. And then Vikas will probably have to prune his presentation a little bit as well. Yeah.
Yes, I can hear you.
Can you see us?
I can see you too. Can you hear and see me?
Yes.
Okay. Is the sound okay?
Yes.
All right.
Thank you.
Thank you. How are you all?
We're well, Shikar. We just heard two presentations. Fortunately, you couldn't hear them. But we're looking forward to hearing you. Some of us have your paper, but most people probably don't have access to your paper. So perhaps you might want to talk about your study a little bit and give us the background as well.
Sure. Great. Thank you, Arun, and good afternoon. Thank you, Sudhir, for inviting me to this to present before you. I'm honored to be speaking before such a distinguished scholars, policymakers, and practitioners. I'm sorry that I can't personally be with you, with the other speakers, and attend the conference in person, but I'm glad at least this video conference technology is making this interaction possible. So, the theme of this conference is extremely important. As we know, in appropriate policy solutions, we need to have a solid understanding of the state of the affairs of the judiciary, and employing empirical methodologies is an important way of doing this. So, to give you a little background, I spent the last 4 months in New Delhi, just returning back to Ithaca a couple of weeks ago, and my main role there as a Fulbright scholar was to conduct empirical studies on Indian courts. So I want to talk briefly on two of these studies. One with another speaker that I at this conference, Nick Robinson, and the second study, which was in addition to Nick, done with Ted Eisenberg, who's a colleague of mine at Cornell and one of the pioneers in empirical analysis of legal scholarship. So noticing obviously that there's not nearly enough officially published data on court statistics in India, and there have also been very few studies that have attempted to generate original statistics, we decided to embark on a project to read, code, and analyze all judgments from the Indian Supreme Court for the 2 years, for the year 2010 and 2011. And I'll present some of those findings, the initial findings from that research. We've so far been able to read 6 months of judgments. Under our supervision, American law students, as well as some from India, have been doing this coding. What they do is they basically enter information into an Excel spreadsheet about, we're looking at things like the gender of the parties, whether the reversal rate, what high court case is coming from, whether the appellee and appellant are governments, individuals, or corporations. And then this data is analyzed using a software called Stata. So here are a few interesting results that I want to share with you, and I'm not sure how they would, some of which would inform on civil litigation, others perhaps not. So what we found is that criminal cases constitute the greatest chunk of the court's docket, which is about 35%, followed by property law cases, which is 17%. And the Kolkata High Court in the 6 months we studied was apparently the highest reversed court. 70% of the judgments coming from that court were reversed by the Supreme Court. And the lowest was, one of the lowest was the MP High Court, with 35% of its cases being reversed. So in terms of, another finding is time. I know that everyone has been talking, I'm sure, today about delays in the court system in India. So apparently it's not as bad as what internationally people believe. There's 10, 15 years of delays. But obviously you all know that in the higher courts, cases move much faster, and this has certainly been confirmed by our work. We found that in the Supreme Court it takes about 5 years to decide civil cases, and 4 years for the court to adjudicate criminal cases. So in comparison, this is, as I said, not as bad as one would the Israeli Supreme Court takes about 2 years to resolve civil cases and 1 year to rule on criminal cases. So the other thing we looked for is reversal rates. I think it's interesting to do sort of cross-country comparisons on this as well. So part of this project is to create data to do this, this international analysis. So the reversal rate in civil cases is 65%, and the reversal rate in criminal cases is 45% in the Indian Supreme Court, which is not very different from the United States state courts that have been studied. In state courts, the criminal cases are also reversed at about 45%, and civil cases at about 53%. So another thing that we look for is, does it make a difference who is the plaintiff, the appellee, or who is the appellant? And it does. There are different rates of reversal based upon what party is appealing and who is appealed against. The highest rate of reversal comes when the government is a loser at the lower court and appeals against an individual. So in about 3/4 of those cases, that the Supreme Court will reverse. So here, what I presented are just very, handful of those findings. I don't want to kind of overwhelm you with statistics. It's definitely a work in progress, and by the end of the summer, we hope to have read all of cases from 2010. And one of the other things we want to look at is this issue of, is the government clogging up the court? I know some people believe that the government files too many appeals. So what we're planning to look at is what percentage of the cases of the court docket is actually the government appealing. So welcome for this study your suggestions on areas of analysis within the rubric of the study that you think would be helpful or that we think we should look at. So I can move on to my second study where I can just see if people have questions, comments, any logistical issues. You can hear me properly.
I think we can hear you. Yeah. Perhaps you should go on to the second one. Yeah.
Okay. So next, what I want to talk about is the study that maybe you were talking about that some of you may have access to, which is also available on SSRN if anyone is interested in looking at it. So instead of generating our own empirical data, what Nick Robinson and Ted did was we looked at existing statistics published by various government and quasi-governmental sources, analyzing over 20 years of data, first from high courts and 6 years of data from trial courts within India on civil litigation rates. We found an interesting correlation, which is that in Indian states that have GDP and literacy rates correlate with civil litigation rates. So in the Indian states with higher GDPs, there's also higher literacy rates. And I know this is a point that some people have also studied in the past. So what this, I think, suggests, it really speaks to some of the law and development literature in the 60s and 70s that tried to make this connection between litigation and development. And some of the implications are that, at least for us in the United States, litigation is portrayed as a negative thing, as a bad thing, and efforts are being made, by tort reform groups to try to limit litigation. And one of these suggests that it's actually a necessary part of litigation of growth and development. What we found was even, I think, more interesting is that not just GDP, but there's an even greater correlation between civil litigation rates and the Human Development Index, which, as many of you know, is a composite of economic, health, and education indicators. So I think the fact that higher litigation rates are associated with high HDI suggests that people are more likely, individuals, to resort to courts when they are better off economically, socially, and physically. So it's not simply that if you have more money, you'll go to courts. I think that this interesting implication for access, people who are concerned about access to justice issues, simply improving macroeconomic conditions in a country won't necessarily improve access to the courts or resort to the courts. It seems like justice requires the government to provide other rights, such as healthcare and education opportunities to people. So another factor that we try to look at is whether there's any correlation between, so just let me back up. So another thing, as many of you are aware, is that in the last 5 years, there's been a slowing of civil litigation growth in Indian states. So that's not a new information for many, but what we tried to do is correlate that with backlog in high courts, and found that there was proportionally less growth in states that have higher backlogs. So the longer it takes to and we measured backlog by how long it would take a court to resolve every case that is before it, given its annual rate of disposal. So there's sort of an interesting correlation that it may be that in courts where it's taking longer to resolve cases, people are more reluctant to file cases in those courts. And obviously, delay is not the only factor affecting civil litigation. As you all know, infrastructure, vacancies on the bench, and corruption are other important factors that are impacting whether people are using courts to resolve civil litigation in states. So I think that one of the important implications I think for the study is that to continue at the rate of important economic development that India is going, we need to process cases faster, and there may be implications for the continued growth if courts are not able to resolve disputes, particularly business disputes. And now sort of speaking without really any empirical basis, but just impressions and my discussions with civil litigators in India, I wonder if sort of informally this is happening within courts, particularly the Indian Supreme Court, which seems to fast track cases that are economic information, like business cases or cases of disputes between large corporations or where foreign investors are involved, whereas it doesn't necessarily fast track cases or even take cases that have human rights implications. And so this may be sort of an informal way that the court is dealing with the delays, but so the economy isn't affected, but there are other people or factors that do become affected, cases that don't get resolved quickly enough, that is fast tracking. And even that's sort of just based on impressions rather than the empirical data that I was talking about. So I think that's, with that I just wanted to turn it over to any questions or comments or thoughts.
Thank you very much. I'm not sure we can coordinate the questions. We still have one more presentation. But I think the advantage is we have Nick here, and we'll ask Nick to probably take questions and comments and convey them to you as well. But thank you very much for hooking up with us and for your presentation.
Thank you very much. I appreciate the opportunity to talk to you. Sorry that it was so rushed and couldn't have more interaction. But if there's any, again, I'm happy to also just listen and observe if that's possible. But if you have another person, if that's easier, I'm happy to also sign off.
Because are you using a projector?
Vikas is going to use a prediction, so we can't have you on the screen, unfortunately, but hopefully we'll find some way to convey to you the actions that you have.
Thank you very much.
Thank you.
I appreciate it. Have a good conference. Good afternoon.
we use the screen, that's what they're hoping we can have both.
Oh, did she?
I was initially supposed to present on the general theme of legal reforms in the country, and then I was shifted to the civil legal reforms. So I was still going to speak on the general legal reforms rather than the civil aspect, because first of all, being an economist, I don't really understand CPC, etc. So I leave it to you, to legal experts to deal with. This is an attempt to understand the problem of pendency in the Indian courts. That the Azim University we have been trying to deal with this issue the last 6 months or so. Just a minute. Now, Sudhir began his morning presentation saying that the problem of legal system reforms has been discussed since the beginning of the 20th century. So there was a Franklin Commission or committee looked into this, and the findings of that committee defined the way subsequent committees and commissions have looked at this problem. Now, yeah. Now, so now though it is true that perhaps that committee's outlook has informed subsequent discussions, it's also true that over the years there has been substantial shift in how we see legal sector reforms. Okay. Now, Now, see, so if you look at the first law commission was established with the purpose of ensuring the justice is simple, speedy, cheap, effective, and substantial. And the subsequent, in 1950, the commission identified the judicial delays as one of the major areas of concern for reformers. Now, the Supreme Court of India, and I think most of you would know this, I won't spend much time on this. In 1970s and 80s, it spent a lot of time discussing these issues and has mostly, during that period, mostly took a substantive rights-based approach. That it is your right to have a speedy trial. Now, but then slowly, if you see, as the liberalization era, as we approach the liberalization era, the entire discussion shifts towards the instrumentalist approach. Because you need to eliminate delays, because delays are not good for economic growth. Okay. Now, it is as if if the delays were good for economic growth, then we would have supported more delays in the system. Now, this instrumentalist approach has its own and then judicial reform began to be seen as a problem of human resource management and infrastructural management. So you need more computers, you need more people. Now this has a number of problems. This approach, most of you know them, so I won't go through these issues. But if you have specific questions, then I can take it towards the end or even now. Now, as an economist, when I joined the Law Governance and Development Initiative, I expected, given the long-standing concerns about these issues, an enormous amount of data at disposal. For instance, even not only the Law Commission, Supreme Court, even the political parties are concerned. So Congress report to people highlights its achievements in the field of legal reforms. And then you have a number of our legislators are actually legal experts, people practiced in the courts. So you expect something that all these 5 or 6 decades of concern could have generated some data. And then then we have some popular concern in terms of cinema, movies, and novels, etc. But then to my surprise, what I found was that data is almost non-existent, and whatever little data we have is full of inconsistencies, gaps. Till now, most of you have been discussing the need for a data-based approach to legal sector reforms in the country. I'm going to spend 2 or 3 minutes on that before I go to the main presentation. See, most of you have a concern about Most of you are concerned about things like quality of judicial sector outcome, for instance. Now, this or maybe satisfaction of individual users. Now, these things are aggregate. As you know, the Grammatico studies. Grammatico and Lakshmi Narayan's framework shows these things are comprised of a number of things. Okay, and then going by Pratap's comment on Tasneem's paper, we need to go all the way from the country, all the way down to the state, district, and then Tehsil, and then Thana. Now the country level aggregates are made up of all these things. So this is aggregation. Here you have to go in this. To study any one of them at this level presumes the existence of data. Okay. Now at present the latest news in terms of data is that we don't know the population of some of the Indian states. The census of Nagaland has been discarded 1971 to 2001. We don't know the area of Nagaland. We don't know the population. Now, which means we also don't know the population density. Okay, and then we don't know most of the interesting things Tasneem talked about most of these states. So we don't have representative data even at the level of states. So even if the NCRB or any other organization prepared to share Thana level data, we don't have the socio-economic correlates to perform an analysis at that level. And so legal fraternity has to be realistic about, there was in the beginning it was, no data, and now it's all about data, but then it has to be realistic about how much can be achieved with the existing sources of data. Now, I'm going to choose an extremely simple case. I'm going to deal with the Supreme Court of India, and I'm going to deal only with the number of cases dealt by the Supreme Court of India from 1950 to 2010. So here I don't have any aggregation issues. I know that these cases filed in the Supreme Court and processed there, and there's a single registrar in the Supreme Court of India. So it's not that 25 different registrars have to be reconciled and then created. So I don't have aggregation issues, etc. So most of you have already discussed the paper, so I won't go into details of any one of them. The only one that didn't figure in your discussion was Murthy and Pravya to discuss the dependency of processing in Kerala and Andhra Pradesh. Now look at the Supreme Court's case load between 1950 and 2010. So the total number of cases is black. Registered total number of disposed cases are green, and the pendency is red. How many times? Was more sufficient for me. Now you see, with this kind of variation, how do you explain this kind of variation in a system? So let me sort of take out the pendency curve and just focus on the number of cases registered and number of cases disposed. How do you explain that between 1978 and 1988 the number of cases registered went up dramatically? What kind of socio-economic changes can support such a dramatic change? And then you have again a dip, and then within just 1 year, the number of cases shoots up again. Now, there seems to be some problem with the data. Before I can go and do regressions on this, choosing all kinds of socio-economic aggregates, I need to understand who has generated this data, who has, and why has he done this, and then how has he done this? Unless, as an economist, if I don't know these things, I won't be able to perform any regression on this. Now think of I'm just trying to see, so there was an emergency here. Did that lead to something? There was an exchange between, I think, Arun and Pratap on this. Now I don't know if emergency alone explains this kind of change. Then here liberalization was introduced, and then something strange happened. Supreme Court, I'll just go back, and here the number of pending cases is extremely high. Supreme Court, I think, thought that the best way of dealing with pendency is to change the way how you count the number of pending cases. Now, no, had they consulted any statistician, he would have told them it would lead to a one-time decline in the base, but the growth rate is not going to change. Anyway, so they did this, and you see almost similar growth rates here. Now, think of Supreme Court is trend. Most of us are concerned about the number of pending cases and how many judges are there in the system. Now, how does Supreme Court's trend changes? If a person who doesn't know the legal system at all, the only explanation he has is in 1961 there was a census, the population changed, and the government of India changed the number of judges as well. Otherwise, I have no explanation here. No explanation at all. Now, for instance, after every delimitation, after every census, delimitation is conducted, and then whenever delimitation isn't conducted, this is explained in the Parliament of India. But here we have no explanations. Now coming back to here, to the end of emergency, so maybe again, but it's just a clue. Now let's see, because now there's so much variability in data, there's so much unreliability. Here the role for legal experts or legal historians to explain to your data handlers how has the code been functioning over these years. But we don't have that kind of data. Now we saw there are 2-3 different humps in the first curve. So let me try to chop this as per Supreme Court's own method of counting. So here again you say, I cannot perform any data analysis in this. So there's so much variation here that I cannot explain it using a usual, even sophisticated econometric framework. And then then this is the post-liberalization era curve. What we can get now, so because of this variability, I have to take out the center part. I have to confine my regression or analysis to 1983, and then from 1999 to 2010, in between the legal system, even at the level of Supreme Court, is an absolute black box for me. No, this is what you see here. Now how so? Now, as an economist, I try to see, I asked all the legal experts around me how delays are generated, etc. So there are 4 or 5 different ways in which the legal system can generate delays. Now to understand Supreme Court's delays and pendency, I need to understand the delays at these disaggregated level. is Mr. Nand Kishore, Supreme Court lawyer, resorting to frequent adjournments? I mean, I'd like to know that. No, fine.
Never.
Okay. Now, so I need
Always ready for my case.
okay. So I need to know things at that level. But then the Supreme Court of India's public debate in country is entirely focused on vacancies as the reason for delay. It's as if, if you have more people in the courtroom, more judges, it's going to automatically solve everything. So the vacancy debate, if I'm not wrong, picked up with the 120th Law Commission report, which wanted 50 judges per million population, and then more recently Supreme Court said that we need to improve this, and in 2011 Justice Kapadia also had a similar concern. Just have a look at this you've already seen. Now the average vacancy in the courts is high. Supreme Court is just for the small period. We don't have comparable data throughout the history of the court. And but if you go to specific high courts, the vacancies are extreme. They vary from 6 to 7% to almost half of the seats are vacant in the biggest high court of the country. Then if you look at the growth in the strength of judiciary, so there has been high courts have been the places where you have least growth. So it could be that it's kind of a kettle drum where this acts as bottleneck. I don't really have more fine-grained data and details about why exactly the number of recruitments are lower at this level. Now let me compare the very limited data that I have with socio-economic indicators. And so the population of India between 1950 and 2010 grew at the average rate of 2%. The net national product by this much percent, by 5%. The per capita national product by 3%. And the sanctioned strength of the Supreme Court by 2%. There's something happening there. The cases registered in the Supreme Court using a trend analysis gives a growth rate of 6.93%. But then if I break this down to two different regimes, 1950 to 83, 99 to 10, then I have a different figure here. Similarly, cases disposed have grown at slightly higher rate than the cases registered. But if I look at cases disposed in 50, 83 and 15 cases registered here, and similarly here, then I see in both cases the disposal rates are lower than the registration rates. Okay. Now, so you see the way the frame I'm choosing is you're telling a different story. If I look at this frame, if I look at this, then I say, well, disposal is much better than the case filing, so there's no problem. Even the existing strength is going to resolve the pendencies in due course of time. If I use a slightly different frame, I would say that the pendencies are going to shoot up in the near future. So now what is happening in Supreme Court? So we need to know not only how many cases are there in Supreme Court, which High Court is sending how many cases, how many different types of cases, and then how many years have these cases been in the lower, etc. Now, when we don't even know how many cases are there in the entire system, how would we know the transition frequencies? Anyway, so now let's see something else. Now, my data, I just need half a minute. Okay? So my data shows that the number of new cases are growing highest in Supreme Court. Lower courts, the number of cases are not increasing. Now, there's a big story there, I won't be able to explain now. Then something is wrong with Supreme Court, because you expect that the number of cases reaching Supreme Court would be the least. So the rate of growth should be the least in case of Supreme Court. We also know that the share of criminal cases in higher courts is increasing, and more number of criminal cases means more time-consuming trials, and it means more pendency. So we have to understand those kind of changes as well. I'll just take 2 more minutes, half minute actually, and I'm done. The standard reasoning is that if you somehow eliminate the vacancies, everything will be fine. And the reasoning is that if I did a simple calculation, assuming that there is no vacancy, and saying from 2006 onwards, how does the vacancy behave? Well, it does half within 3 or 4 years. But this ignores a number of problems. If the system is more efficient, more people are going to approach it. So pendencies may not decrease. If the higher processing rate would increase the number of civil cases, and number of civil cases would in turn, improve the processing rate of. But then there will be decrease in demand for illegal activities, and which could lead to a decrease in filing of cases. So we need to see a general equilibrium kind of way of looking at the problem rather than linear extrapolation. So my last 2 points are, well, let us assume that you really need 50 judges per million. Where is the trained manpower? Okay, where is the trained manpower? How are you going to fill these vacancies? No policies, whether Dalits, women, OBC, etc. would be represented. We don't know. We don't have any career path for the people who are going to join at this stage. And then, let us forget, all these problems. The current budget for the legal system is 6,000 crores, and if you want the entire wish list to be fulfilled, we need to make an initial investment of 90,000 crores and 45,000 crores every year. So these are Vivek Debroy's estimates. So some my estimate, but he seems to be on the mark here. So then my question is, that I'm picking from Siddharth's previous presentation somewhere else, that do we really need such an expensive way of resolving our disputes? Are there no other alternatives? As per one of the Press Information Bureau's 2009 release, the majority of cases of check bounce, traffic ticket, etc. Can we not simply change the check bounce laws to have to resolve the check bounce pendency? I'll end with this and questions. Thanks a lot for.
We have about 10 minutes. But hopefully some of the questions and issues that Vikas has raised will be answered in tomorrow's sessions as well, or addressed rather in tomorrow's sessions as well. I think Nick can...
in fact, there's a lot of it we want to touch on.
Yeah, because there will be some replication, so we can hold off some as well for that. Maybe let's take a handful, maybe a few, yeah? Can I see?
Just a comment. I think the issue of selectivity, Supreme Court has many jurisdictions. So one jurisdiction is of appellate jurisdiction, other jurisdiction is constitutional jurisdiction. Now, we need to take a call. Supreme Court, does it have to have an appellate jurisdiction? I mean, why does it have to hear, divorce cases all the way up to Supreme Court, and issues of check bouncing? They do go to the Supreme Court all the way. India experienced in late 70s and early 80s. And then Mexican federal court cut down and restricted, confined its constitutional jurisdiction, very much similar to what Indian Supreme Court is doing now, confining the rules of locus standi. That we need to look at the Mexican federal court example, and there are studies on that.
Okay, so the comparative element. Any other points or questions that you have? Sorry, yeah, Jen.
This is actually a general question which came up from Nandkishore's presentation, but if anybody else wants to address it. The common thing came up even in his thing of the Evidence Act is that the judges don't know about many of the procedures. And the same thing is happening in newer legislations as well, like the DV Act. So, what is the solution for that? Supposing we make amendments, we make simpler procedure. Do you train judges? We have been doing trainings, but the trainings are not really resulting in better procedural implementation. Or do you get better judges, or what do you do? So I mean, is training the answer, or is there any better way to ensure that all these advantageous procedures ultimately are implemented in the courts?
I think that's also the final session about institutions which are already doing this, the judicial academies and others. That's partly, I think, the place where things like that can be addressed. Yep.
No, I think Jenna raised an important point. One other way of thinking about it, in a sense, I think it's implicit in Nankishore's presentation as well, actually, in the CPC and the references to Macaulay. So the one thing we do know is most successful law codifications are products of elite consensus that have the capacity to have their will enforced when they actually do it. Right? I think the big challenge we are facing now in the legitimacy of law itself is, in a sense, one, we have democratized, right? And that's in a sense the good thing. But what is the form of negotiation that produces a shared understanding of this law is actually no longer available. I mean, the interesting thing, just had recent experience of interviewing 100 High Court judges. There's an oddity about this question of what do they know, right? So if you administer it as an objective type test, right? What is CPC or 50? They know, right? Do they really know it, right? And I think the interesting, because for us, I think, if you think about it, this is not a problem peculiar to the judiciary. This is a problem peculiar to the expansion of all professional institutions. Whether it's accountants, whether it's higher education, whether it's medicine. So I think we need to sort of think at that level as it were. The education training part is certainly one in a sense component from it, which is when, as in I think Vikas has great data on the Supreme Court, when institutions go from small low-level equilibria to this completely, where quality turns into quantity, as it were, without, and which is inevitable, then how do you create a dialectic that it turns back into quality? And I don't think across a range of institutions we have a clue about how to think about that.
Maybe the authors might want to react or any other things. Both Vikas and Nankishore will probably end up.
Just make a small remark about restricting the jurisdiction Supreme Court to just simply shifting the problem from one level to another. Those cases are not going to disappear. The issue is not who has to deal with them. The issue is that why is no one able to deal with them? And so just by shifting the jurisdiction won't have any impact. It'll just so we need to think hard about the way the legal system is structured, the way our laws are made, and the way they are implemented, and then try to find solution rather than doing cosmetic change in the territories of different courts.
Yep, go back to
Others? What I was struck by in the four presentations is the differences in method. And so when Vikas presented last, he mentioned why he had difficulties thinking about how this might have changed, and there might be interesting just rule changes or interpretation changes. I think one of the things that could be useful is the expansion of the especially petition jurisdiction, which Dhawan hints at, but it happens around that same time, and that could have changed the dynamics of the Supreme Court's
I
docket.
can show you the numbers for the recent years tomorrow.
So he's going. So Siddharth will look at that. And my sense here is that look at the range of skills, and the same with the presentation by Osama. That I'm sure that many people have held their comments, but they could point out 20 different reasons why that kind of an empirical survey was simply not that useful. And sort of from an empirical survey method point of view, it's a sort of a weak survey. And then that's what lawyers do, right? So Nand Kishore does an analysis which is historical and doctrinal, because that's what we do, and that's what we know how. That's what we know how to do. And the people who do econometric work do that kind of regressions, data analysis, but the range of explanatory circumstances are just so wide to try and explain what the universe of the disputes are about. And my sense is that while Vikas is right to complain that lawyers have been neglectful of generating the data, there's a problem of knowledge, just knowing how to do these things. And in some ways, that is big part of this puzzle. That people with very different skills are called on to tackle these very complex phenomena, sticky phenomena.
If I may just answer Jaina first. I think your question was about what's to be done about the fact that judges may not know about the procedural codes and the law. I think, see, what I'm trying to get at is that judges are not doing their job well in terms of interpreting the law. Theoretically, whenever you interpret the law, you're involved in the process of discovering the set of principles which make it work. So that they're not doing very effectively. Just to give you an example from the top of my hat, if you look at the Halsbury's Laws of England, it's a England has the common law system, but they've managed to put everything together in something like 25 or 30 volumes. Halsbury's Laws of England is in 30 volumes. That's the law. So you get the latest decision on the subject and so on. So that's the level of clarity that they have. Because here in India as well, there's what's called, I think, Halsbury's Indian Law of something.
And there's also a new initiative by ILI.
But it's nowhere as, at least the chapter on civil procedure is nowhere as clear as the chapters which are written in Halsbury's. It's just because the way in which we've organized our doctrines is not, judges are just not good enough to do that. Because you need scholarship. So if you get a question about section 9 or section 11 of the Civil Procedure Code, to answer that you need to know not just section 11, but all the other sections and provisions of the code, the entire object of the act and the scholarship behind it. Only then will you give an effective answer to this. Because then you see it as fitting into the framework very effectively. If you don't have that kind of scholarship, you will only answer this limited question. You see? So I think that's the thing. So first of all, at the level of doctrine, judges are ultimately, they are doctrine makers. Okay? Whether you accept Hart's theory or Dawkins' theory that they don't make law, they discover it, or you say they do make law. End of the day, they lay out legal doctrines in every area of law. And if they don't have the scholarship to do that, it's going to be at the very start, it's going to be difficult. Next is the question of implementation and learning the law, which is a question, which is an empirical question in the sense, how do you train your judges? You make sure they go through exams and so on and so forth, which I think is a distinct issue altogether. And coming to Mr. Pratap's observation, I agree with you totally that so then now you're faced with the question of what do judges really know and what are they applying when they decide cases? Because if a case falls under the square ambit of a rule, if they're able to answer it with certainty and in the way in which you expect them to answer it, and in every other case where there's ambiguity, you don't know where the case might go, then what are they doing in the courts? Is it the rule of law at all? Very many times we see that in cases you just don't know what's going to happen. If some litigant comes to you with a case, you can never tell him, okay, this is going to be the result. It's like, dekh the hai, we'll give it a shot. And I think this is the sort of system that really benefits people who have a vested interest in maintaining such a system.
Okay, so we're just at 4:30, so please join me in thanking the panel. There's coffee outside. There's the 6 o'clock lecture which Pratap Mehta is giving. Coffee is upstairs, sorry. And hope to see more of you for the lecture and the sessions tomorrow.
Sorry, just a small amendment. There's coffee. There's a public lecture after this at 6:30, which Mr. Pratap Mehta will be giving, and tea and coffee with snacks is being served there at NGMA. All of you are very cordially invited. There's a bus that is going to leave for the speakers and the moderators primarily from outside Terry in about 15-20 minutes. We're willing to explore other options of getting everybody else there. but the bus has a little bit extra space, so it's mainly for the speakers in the morning. And we've ended bang on time. We promised Terry we'd end at 4:30, and we'd like to thank all of you for your cooperation. We know we cut down on lunch time and tea time, and we've ended on time. Thank you very much for your
So I thought it was